We need Mr. Hawkins, I believe it is.
Mr. Hawkins, if you could please turn on your video.
Ah, there we have him. Thank you so much. Okay. Mr. Benson, my understanding is that you are here on behalf of the appellant, so I will ask you if you wish to reserve any time for rebuttal.
Yes, Your Honor. I request 5 minutes for rebuttal.
Okay. So noted, and I will let you know when you arrive at that destination point in your presentation. You may begin, counsel.
May it please the court. I represent the appellant, David Shevchik, with co-counsel Margaret White Small. At this time, as we've already requested 5 minutes for rebuttal. This is a post-dissolution of marriage appeal challenging the trial court's order awarding attorney's fees and costs to the former wife. A little bit of background on this case. There was a final hearing scheduled in June of 2018 for the final dissolution. Prior to that trial, the parties entered into a stipulation in their pretrial memorandum, an agreement that essentially bifurcated the case, where the understanding was that there would be a second final hearing to address the attorney's fees issue and the division of some personal property. After the conclusion of the trial in June of 2018, the court entered its final judgment order in November of 2018. And in paragraph 31 of the final judgment, the court acknowledged that the parties had reserved jurisdiction to determine each party's need for attorney's fees. It went further than that, though. It also said that notwithstanding the stipulation, the court finds that the wife is entitled to attorney's fees and costs, that she has a need, and that the husband has the ability to pay. Absent that boilerplate language, there is no other mention of any factual specific findings to the wife's need or the husband's ability to pay.
It's my understanding that following the entry of that judgment, a notice of appeal was not filed. Is that correct? Rather, a motion for rehearing was filed.
Correct, Your Honor. There were several ancillary motions afterwards that were heard a year later in 2019 that had nothing to do with the reasons.
In the former husband's motion for rehearing, was this alleged violation of the party stipulation regarding reservation of jurisdiction as noted in the compliance with the pretrial order noted to the trial judge in the motion for a rehearing filed by the former husband?
No, Your Honor.
Okay. The trial court then entered an order denying the motion for rehearing. Is that correct?
There were several motions for rehearing. The one became a moot point. The other two were on former wife's motion for rehearing.
I guess my point was there wasn't a notice of appeal taken after that to challenge the provisions of the final judgment. Is my understanding of the record correct on that point?
Correct, Your Honor.
So the only issue that we have here filed in this notice of appeal is the attorney fee order itself?
Well, Your Honor.
And the motion for reconsideration that was denied.
Well, actually, Your Honor, the order entered by the trial court is a fundamental error that shows a clear violation of due process that can be raised for the first time on appeal. The other errors that we will get into also likewise are based on sufficiency of the evidence or clear legal error that don't require a motion for rehearing prior to going straight to an appeal. After the supplemental final judgment was entered in September of 2019, again, dealing with ancillary issues that had nothing to do with attorney's fees, the court once again in one paragraph reiterated that the court had already determined wife's entitlement to attorney's fees and that the only issue going forward was the amount of those fees that would be determined at another hearing. In September and the following month, October and November, over 2 days, the court heard former wife's motion on attorney's fees and costs. In February of 2020, the court finally entered an order on former wife's motion for attorney's fees and costs, awarding the wife $49,565. The court's ruling awarding the attorney's fees must be reversed because it is based on several errors of law that led the trial court to erroneously make factual findings to support that award of fees. Error number one, Your Honor, was that the court went ahead, despite the stipulation and agreement of the parties who did not have an opportunity, because the understanding was there would be a second hearing to present their evidence and case concerning attorney's fees and costs. The court found entitlement without a hearing. That is a clear due process violation and is fundamental error and can be raised for the first time on appeal. The second.
Well, here's my concern about that, Mr. Benson. I would look forward to your response because as I'm mulling this over, the cases that are cited in the brief seem to have a very similar procedural context. The trial court ignored the stipulation of the party and proceeded forthwith to enter a final judgment of some description. And arguably, in the very short case opinion, doesn't even say why it's an error, but I would agree with you, at least I lean towards the notion that it's a procedural due process. But in this case, we had a final judgment, a motion for rehearing. We had further hearings, discovery was taken. There was every opportunity to bring to the trial court's attention this stipulation and how your rights to procedural due process were arguably infringed upon, and yet it proceeded to a resolution with interrock. I think it was, more financial records, interrock, the whole thing. It looked like a mini trial, and yet nothing is mentioned about there's a paragraph N. I'm trying to remember if that was the right paragraph of the pretrial order.
Well, actually, Your Honor, I think a lot of the buildup to the actual hearing on the attorney's fees dealt with the division of the personal property. As far as the due process, this issue wasn't a final adjudication until the actual amount was determined. So it would have been premature, and they would have been, my client would have been for.
Let me ask you, going back to your point about it being fundamental error. For it to be fundamental error in the final judgment, wouldn't you have to appeal the final judgment?
Our position on that, Your Honor, is that the due process violation is a fundamental error that is allowed to be presented for the first time on appeal. There's no.
Yes, but that assumes that the appeal notice was properly filed in the jurisdiction of this court, was properly invoked. The notice of appeal filed by your client here says that you are appealing the order on the amended motion for attorney fees, and I think it was the order on respondent's motion of reconsideration. So my concern is, how then do you get to the errors that were, as you argue, in the final judgment in the absence of a timely filed notice of appeal that would invoke our jurisdiction to review that fundamental error? It sounds as though we are coming to this from the order on attorney fees and using it as some sort of conduit to go back in time to raise an issue that arguably should have been raised earlier. That's my procedural concern. And I know you've probably thought about this, so I look forward to your response.
So, Your Honor, it's actually a building block. So it's not so much the final judgment had disregarded the stipulation, and then it set into motion the findings that the court started from at the motion for attorney's fees and costs. The starting point at the motion for attorney's fees and costs presupposed the entitlement and that there was a finding of need and ability to pay, which the evidence clearly showed that there was not. The second order, the second error by the trial court stated, actually, there was never, ever, throughout the beginning, through the final judgment, through the supplemental final judgment, or the transcripts of the hearing or the order, there was never any mention about the former wife's need for attorney's fees. That was never, ever addressed. Furthermore, the court found in the order on attorney's fees that the former husband's income was $300 more than the former wife, when the clear evidence, the undisputed evidence by the parties, financial affidavits, tax returns clearly show that the former wife's income was $3,530 per month, and that the former husband's income was $3,025 per month. After you take in the $2,200 obligation the former husband had in alimony payments to the former wife, that left the former husband with only $825 to cover his expenses. The testimony was clear that because of his expenses, he actually had a deficit of more than $3,700 each month. He didn't have the ability to pay. He was required, or he had to, in order to cover his expenses, dip into his non-marital IRA assets to cover his expenses. So the court's finding and the order on motion for attorney's fees clearly on that paragraph alone was clearly erroneous. There was ample evidence to show that the wife actually had a $2,705 better income status than the former husband.
Is that including the Social Security income that was imputed or not?
No, Your Honor. The problem is that was the second, the next issue is that the court imputed Social Security benefits to the former husband when it is clear on the record, undisputed. Even the court had an exchange with the client in the transcripts where she acknowledged that he was not receiving those benefits.
But it was imputed to the former husband in the court, in the final judgment. And getting back to what Judge Casanueva was pointing out, we're not on appeal of the final judgment. And so go on. You're not coming through, so go ahead.
No, I didn't say anything.
Okay. And so it seems that you are trying to use this motion for attorney's fees to sort of backdoor a challenge to determinations that were made in the final judgment and have since been, rendered final. The time to challenge that would have been on direct appeal of the final judgment.
Your Honor, the former husband is not challenging the award of attorney's fees. And the award of attorney's fees for that specific and limited topic, it was agreed that the Social Security benefits, if he were to take them, would be imputed to him for the sole purpose of only determining alimony. It's notated at the bottom of the sheet that this is only for calculation for alimony purposes only. It was never intended to be used for an attorney fee determination. In fact, once we get to the attorney fee section, I think we start from square one and have to begin our analysis again, because we have to look at what happens after you implement the final judgment, how that affects the parties. Because after you do your equitable distribution, after you account for alimony, that could change the ballgame. And here, it clearly did. The former husband never had the ability to pay attorney's fees. The next error the court made, Your Honors, was it incorrectly, based upon the evidence, made the statement that because the husband had substantial, significant non-marital assets over the former wife, that he should be found having the ability to pay. The figures that were used of $380,000 to him and $90,000 to the former wife are erroneous. They are based on figures from 2017 at the date of filing, not at the date of this hearing. The testimony from the Motson Associate Financial Planner and the testimony of the client clearly show that those assets, by the time we get to the hearing on attorney's fees, had been depleted. They had gone down to $44,000 for one account. In essence, what he was left with was about $80,000 available to him, not the $380,000 that was being propositioned. In fact, the numbers that the court used was clearly, and it was brought to the court's attention that these numbers were outdated. And despite the testimony from all of the people, for some reason, I don't know where the error came in the notes, but I don't know how we go from $380,000 down to $80,000 with such a huge discrepancy. But that was the testimony undeniably. Opposing counsel at the trial court level would like to have the court focus only on what the values were at the date of filing or at the date of the final judgment, which is incorrect. I think you have to look at where the parties are at the time of the hearing to determine the need and ability to pay. Here, clearly, it wasn't a 61-39, I think the percentage split the court states in its order. Rather, if you look at the attached supplemental exhibit, it clearly shows when you factor in what the testimony was, what the records show, the actual split was a 54-46 split, okay? It went from about $600,000 available to the husband and $505,000 roughly available to the wife of combined marital and non-marital assets, with the understanding that part of the marital assets, the husband was handcuffed because he had a restriction of only being able to access 10% of that account, which equated to about $12,000 a year. So whether it be the husband didn't have the ability to pay, the analysis—
You are at 15, just so you know.
Oh, thank you, Your Honor. I will end with the fact that after the percentage, the court also based its determination for attorney's fees on the made-up factor of the attorney fee for the former husband was a bargain, and therefore that should entitle the former wife to attorney's fees. I will rest there, Your Honor.
Thank you, counsel. Attorney Hawkins, you are muted, so before you start, you may want to unmute your mic. Still muted. There we go.
That would help. Thank you, Your Honor. My name's Jack Hawkins. I'm an attorney from Bradenton, Florida. I represent the former wife, Shelley Sutton, formerly Mrs. Shevchuk. I want to talk about, there's a number of things I would like to talk about. One is the stipulation. Well, I'll just address that right out of the box. It's our position, aside from the appellate issue, and I certainly respect what the court has said about why didn't you appeal it. That was part of my brief, but there was no lack of due process. There was no prejudice. When I received the order, the final judgment had, okay, I know you guys reserved her fees, but I think the former wife's entitled to fees. I didn't think anything of it because the court still had reserved jurisdiction for the amount. Opposing counsel obviously didn't think anything of it because we proceeded as if it was a non-factor. That's how we proceeded on the case. I want to talk about Social Security too, please, Your Honor. That's interesting that they are taking the position, well, he really didn't have any Social Security income. Well, it was presented in a way that he did, or he intended to take it 2 days after the final hearing. Final hearing was at the end of June, and he was eligible to take his Social Security July 1st. Every single option presented by the former husband included Social Security analysis, every single one. And I want to read one thing.
Now, when you say he would be eligible on July 1, would that be the magic age of 70?
I believe so.
Right. Okay.
I'm not positive.
Because I think part of the argument was he wanted to wait till he turned 70. So that was a linkage I made, but I would like to make sure I'm correct on that. But it's all right. Don't use your time up. I can go back and look.
Okay, fine. Thank you. But I want to read something from the record. It's important. And I'm reading from the former husband's brief to the court after the trial. This is what the former husband was saying to the court. Hey, here's where we are on alimony. Here's the evidence. Here's the Social Security figures. If you look on the record, page 889, he says the husband would request any durational alimony awarded be tax deductible as calculated by Chris Wayland on Schedule 12. That's Exhibit 12. Exhibit 12 had alimony, had Social Security calculations all riddled through it. Probably one of the most important comments in this brief, and it's on page 888 of the record. The former husband says to the judge, complete testimony with specific verifiable amounts were testified to by Chris Whalen, CPA, et cetera, et cetera. Attachment E to this memorandum shows calculations based upon actual income of the parties for alimony calculations. It was the law of the case at that point in time. It was the law of the case. I want to address the assets because I think that's something that stands out. The actual assets that were deliberated over at the fee hearing included updated financials. There was updated reports from the Mott and Associates, the common financial advisor for both of these parties. And pardon me, just a second. The numbers that were used were really presented by the former husband, and there's a figure there that floated throughout these 380,000 non-marital assets for the husband, only 90 or 95,000 non-marital assets for the wife. Those floated around. When you got to the final hearing, yes, the husband's non-marital assets had been dissipated to some degree. What did he do? Well, he took 150,000 of it and he bought out the wife's interest in the marital home from his non-marital funds. It is important to note that that was not contemplated. The stipulation on the marital home said as soon as the husband gets refinancing, he is going to pay the wife the $150,000. He didn't do that. Okay, he didn't do that. He took his non-marital money. And so the one nice thing, and I compliment and thank opposing counsel on this particular aspect about the true marital assets. And I'm looking at page 22 of the husband's brief and page 23 of the husband's briefs. And this is really good because it really drills down. And it says on that, in this argument, thus, it is uncontroverted that the former husband's non-marital assets after implementation of the provisions of the final supplemental judgment consisted of a total of $196,865. That's an accurate figure, but that's not all his marital assets, because he had an asset in him. He had $150,000 of equity in his marital home. That's a marital asset. Okay, I guess. When the wife got paid her marital asset of that, it became non-marital. In fact, at the time of the hearing, the fee hearing, the husband had $300,000 of assets of equity in the marital home, and he had $196,000 of non-marital assets, compared with the wife's assets at about $98,000. I think it's disingenuous. Good arguing, but disingenuous a bit to suggest that the wife's $150,000 automatically became non-marital when she got paid off, but the husband's $150,000 still remained marital. And the other important thing is he got an equity line of $176,000, and so he had the ability to tap back into the non-marital assets. He had that ability. It was clear as day. So did the husband have $386,000 of non-marital assets? Pretty darn close. Pretty darn close. $346,000 to be exact, if you add back in the $150,000. As to, so in sum, there wasn't a very large disparity between the parties, and that was accounted for, and it was provided to the court at the hearing for the fees. The lack of findings I find not applicable. There were very clear findings in all of these orders. The final judgment made a finding as to gross income, net income, the tax effect of all of these things. It made a finding of the marital asset split, non-marital partner split. And that was noteworthy. But that substantial disparity of non-marital assets continued all the way through this case. And the husband still has the access, has the ability to do that, along with $80,000 in cash, I guess. Yes, he has that ability. So my position is this case should be per curiam affirmed. I just think it should be. I'm happy to answer any other questions that the court may have of me. Thank you.
I don't see any questions, so counsel, thank you for your presentation. And let me clear my records and we'll move to the counsel. You have 4.5 minutes remaining for your rebuttal.
Thank you, Your Honor. Just to clarify a point, at the time of the hearing, the former husband was 67 years old and was electing to wait till the age of 70 to maximize his Social Security benefits. As far as the final judgment and that hearing and the income imputation and all of the discussion about these fee schedules, taking into account the Social Security that he was going to get or may be getting, again, that it was very clear, and it's notated on the evidence, that that was for the limited purposes of determining alimony, not for determining ability or need for attorney's fees.
Mr. Benson,
yes.
can you give me the record site for that notation, please?
If you look at the financial affidavits that were filed, clearly show that he was not collecting, he was not including Social Security. The testimony from the client is clear that he was not collecting Social Security. And the bottom of the fee schedule, it's one of the fee schedules that was presented, has it in very, very small print at the bottom that says, this is for the limited purposes of determining alimony only. That was the only reason.
But you don't have a record site for me for that?
No, Your
If
Honor.
you did, okay.
Okay. I mean, it's uncontroverted that he was not receiving the benefits. What opposing counsel for what the former wife's counsel is trying to say is that because alimony was determined and these figures were used, that it therefore should automatically carry over to show what his income was for alimony. That's a red herring. That dog don't bark. It doesn't work. Because when you get to the attorney fee portion, you start from square one with the analysis of need and ability to pay of where they are at that time. And assuming for whatever reason what happened at the trial court level for the final judgment, that's irrelevant to when you get to the hearing on the motion for attorney's fees. From that time forward, the evidence at that time should be based upon 2019 figures and where the parties stood. Instead, former wife would like to go back and only use the figures from 2017. As far as the argument that the husband took out an equity line, that he could have refinanced, that he had access to all this additional money, there is no obligation for a spouse to take out a mortgage to encumber a personal real property to cover attorney's fees. There's no obligation. So I don't know where that is coming from, other than maybe another red herring. Counsel for the former wife also mentioned that the assets were still disproportionate. Again, the numbers and the figures that counsel is referring to, like he did in the supplemental final judgment and in the motion for attorney's fees, the exhibits that were provided were all outdated numbers. None of them were current numbers, because if you use the current numbers and you go by the testimony of the financial advisor and the clients themselves, it is very clear that the numbers are not as far apart as he would have you believe. They are as we have stated. So there was no ability to pay. There was never a finding of need. In fact, ironically, the former wife had the ability to come up with the initial $39,000 out of the joint marital funds to hire counsel, and also had the ability to pay $40,000 right after she received her portion of the marital proceeds when the husband paid her off. So she apparently had the ability at that point. Your Honor, for that reason, we would ask that the order be reversed and vacated or remanded to make more specific findings based upon the evidence that was presented. Thank you, Your Honors.
Thank you, counsel. Thank you both. And we'll let you exit back to the cyber location from which you came. Hope you all stay well.
Thank you, you too.
We will call our last remaining case.